Your case has gone to trial. Your attorney is in the middle of giving his opening remarks, and you're thinking in the back of your head, should your attorney be telling the jury at the end of his remarks how much money you are seeking as compensation for your injuries? Would you like to learn the answer? Come join me as I share with you this great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury trial attorney practicing law in the state of New York. Now, at the end of opening remarks, there are some attorneys who will ask the jury to award a verdict in favor of his or her client. Why? Because they want to put that seed in the juror's mind that that's what they're leading to, that all the testimony and the proof that's building up is going to lead to him asking for a verdict in favor of his client. And that's natural. But let me ask you this question. Don't you think the jury knows that? Don't you think they understand exactly why he's there? There are some attorneys who turn around and say, you know what, I think the better practice is to ask the jury for a particular amount of money at the very beginning during opening remarks. This way it plants the seed in their mind that this case is worth $3 million or $5 million or $10 million, and now they begin to think and keep that in their mind as they go through the entire trial. Let me share with you why I don't think that's the best strategy. At the very beginning of the case during opening remarks, the jury has not yet been able to evaluate the testimony. They haven't been able to determine who's right and who's wrong. They don't know yet where the injustice was. If the attorney turns around during opening remarks and says to the jury, listen, my client is entitled to $10 million and we're going to prove it to you. What happens if during the course of the case he doesn't prove it, or doesn't prove it to the extent that his client is entitled to that much? Now, in my opinion, he's lost credibility. He now has to live up to that. And if, God forbid, he does not, or if the testimony doesn't come in the way it's supposed to, what will then happen is the jury is going to think that the attorney overinflated his request, and that could be a dangerous thing. You know why? Because the jury could turn around and hurt the client because of it. But this particular type of strategy is most often not used because you don't want to put that seed of doubt into the jury's mind that, listen, now I have to live up to that amount, rather than, let me show you what the value of this case is, let me show you what the testimony is to support our request. Most attorneys will do one of two things. Either they will ask the jury to award a specific amount of money for economic losses and the harm that the person has suffered, or simply say, listen, I leave it up to you to decide how much my client is entitled to. And again, it varies depending upon who the attorney is, where the case is pending, what type of case it is. So there's a lot of different variations. So why do I share this information with you? I share it with you just to give you an insight and an understanding into the different tactics and strategies that are used in different types of cases here in the state of New York. You know, I recognize you're watching this because you probably have questions of your own about your own matter. Well, if your matter happened in New York and you do have legal questions, what I encourage you to do is pick up the phone and call me. I can answer your legal questions. This is something I do every single day, and I welcome your call. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. Well, that's it for today's quick video. I'm Gerry Oginski here in New York. Thanks so much for watching.